you all for coming out at this early hour. And welcome on behalf of Michael Green and all of us associated with Green's List. Michael has been something of an innovator in the way in which, as a clerk, he's sought to establish points of connection between members of the list and the wider legal community, and that's been done in a number of ways. We've, as many of you will know, have regularly have breakfasts with guest speakers, ranging from people like Tommy Hafey to Walid Ali to renowned economists. Our website has on it a collection of research from members of the list, which is available there for those in the profession who would care to access it. This seminar is one of I think there's something like 30 briefings, Michael, that are being conducted in all sorts of spheres, ranging from wills and administration right through to criminal law. Today we will start off with a presentation by Justin Hannebery in respect of committals. That'll be followed later on after a coffee break, which we hope will occur between about 8 o'clock and 10 past 8, with Pat Doyle giving a presentation in respect of bail. Both of these are topics which are very much at the forefront of the day-to-day practice of criminal lawyers. My particular interests have been in committals over the years and the way in which they're run, and it'll be with great interest that I wait to see what Justin has to say about those. One thing I wanted to raise before I did sit down, and that is that it's come to my attention that there have been some members of the profession who've mentioned to me that they only became aware at a late point in time of the fact that that these breakfast seminars were on, or that particular seminars were taking place. I think that's probably got something to do with the fact that we'll communicate with the central repository for emails at a particular firm, and it doesn't get beyond that. What I'd urge you to do, to be sure of obtaining details of further seminars that we're conducting, is to ensure that you personally are registered on the Greens site as somebody who wants to receive material from us, and that way it'll go directly to you rather than through a convoluted route where you might miss out. But without further ado, could I ask Justin Hannebery to start to enlighten us to some extent in respect of committals.
Morning everyone, thank you for coming out. I can assure you it's one of my favourite things in the world to get up really, really early to hear a lecture about legal issues, so thank you for coming along. I've prepared a paper which I think was available, was it at the door? And in that paper I've alluded first to the fact that committals are one of those perennial debates in the criminal law that arise all the time. I went back as far as 1986. I could have gone back much beyond that to hear the differing opinions as to whether committals are, to quote Jeremy Rapke, a costly and inefficient time-wasting process, or to quote the committee back in 1986, a vital cog in the machinery of criminal law. A couple of points about that debate, though, is that one thing's clear: the DPP and indeed his predecessor wants to get rid of committals. They're shameless about that desire, and to some extent, committals and their ongoing existence and the use of them isn't something that as practitioners, and certainly from the defence perspective, should be taken for granted. They are always under threat, they are always under review, and each and every review of the criminal justice system has gone directly towards investigating whether there's some way to eliminate them, shorten them, in some way vary their purpose, to take them away from what they currently present to the criminal justice system. I know now Justice Paul Coghlan used to be fond of saying that it was he that decided who stood trial in the state of Victoria, not some magistrate. And frankly, it's hard to argue with that. That is entirely the way in which the system works. I know Jeremy Rapke, in support of his arguments for the elimination of committals, refers to the case of Bandali Debs, where he was discharged at committal for the murder of Ms Harty. He was directly presented, I think, maybe within a day of that discharge, and as Jeremy Rapke points out, well, if I can do that, what's the point of these things? Counterintuitively, it would seem that the success of defence practitioners in getting discharges seems to be, in the media, the main way in which committals are supported. It's interesting the way the media works, in that you could throw up 1,000 statistics about how this system works and how many times matters get resolved. However, until you've got an individual case that seems to capture the public's attention and seems to encapsulate what's good about committals, it doesn't really seem to get much resonance. Now, one of those cases was the Theophanous case last year, and you'll all recall Mr Theophanous going through what seemed to be fairly elongated proceedings that resulted in his discharge at committal, and I note that there was no direct presentment after that fact. I picked up what Paul Austin, the political reporter for The Age, said about that Theophanous case, where he said, "A third thing to say about this case was that it was a stunning example of the value of committal hearings. Victoria's Director of Public Prosecutions has called for committals to be abolished. Theophanous would surely disagree. Theophanous was spared the added trauma, and the court system was spared the added cost of a full jury trial before a jury." Now, it's interesting the way in which the media picks up those things, because when you look at it, Theophanous was absolutely an atypical case, in that it was a case where a complainant has clearly sworn up to her statement in the normal way, has then been cross-examined and has then been discharged. He's then been discharged at committal, it would seem, despite the fact that there has been evidence, namely the original statement, that the complainant has sworn up to. But the fact that it's atypical doesn't necessarily take away from the fact that that does seem to have been the greatest bit of public relations committals has had in recent years. The other thing to note is that the support of the courts for the committal process has been something that has been a big factor in keeping them going. If you look at the statements generally from the court in Barton and the Queen, that those are statements of broad support for the concept that it is an important feature of a fair trial that somebody has the opportunity to a committal hearing and an opportunity to flesh out the case before them and understand the exact way in which the Crown case is put. No doubt, though, in recent times, those wishing to restrict the right to committals have had a degree of success. Committal proceedings in relation to sexual offence matters have been absolutely stripped back now. They're so limited now, and certainly under the new Evidence Act and Section 124 that restricts cross-examination of someone who is, 120... the Evidence Act that stripped back the right to cross-examination of someone who is a complainant in a sexual assault matter really does mean that for most of the time now in a sex case, you're going into a trial absolutely blind, and I think the proof will be in the pudding about that as to whether that results in less fair trials and perhaps more retrials. Now, having said that, I think the message out of all that is that you can't take committals for granted. They are under threat, and that it is, in a almost direct sense, the performance of defence practitioners in the course of committals that are going to determine whether committals continue or not. From that perspective, it's important to understand what's in it for an accused to proceed through a committal hearing. Now, I've deliberately done this from the perspective of the accused. There are stated purposes for a committal that are the broad public policy purposes for it, but really what it comes down to is that when you're acting someone, you want to know what's in it for them to do a committal. Now, a committal represents, when you think about it, the only opportunity that most accused get to do any kind of investigative work in relation to the criminal allegations against them. Now, if you think what a criminal trial is, it's a contest between the individual and the state. The state has the resources of the OPP, they have the resources of the police force. Anyone who's ever done a trial and has received extra witness statements throughout a trial, before a trial, extra investigations being done, will understand that on that level, it's not a fair fight. An individual accused, unless they are unbelievably well resourced, simply does not have the ability to do the level of investigation into a matter that the OPP can and that the police force can. That, to me, is a huge access to justice issue. The committal represents an opportunity for an accused person to, in a controlled environment, undertake their own investigations into a matter, have them recorded and have the witnesses made available to them prior to a trial. Think about what the alternative to that would be, and the alternative does exist. I think certainly in Western Australia they do it entirely on the papers. The alternative is complete reliance upon the witness statements as they've been presented in the police brief. Now, the importance of a committal, I think, is outlined by an understanding of exactly what these witness statements represent. They represent what one, maybe two police officers chose to ask a particular witness on a particular day. Doesn't say they asked everything you wanted them to ask. It doesn't say they asked it in a good way. It just says these are the things that were asked of this witness on this particular day, and this is the way we recorded it. Now, whether that represents an absolutely accurate state of the witness's evidence, whether that represents a complete statement of the witness's evidence, is something that can only ever be discovered when the witness themselves has to give that evidence in court. The other issue too is that witness statements themselves are very difficult to use at trial. It's much easier to put to a witness an individual question and answer from a committal proceeding than to use a 5-page witness statement that you want to put one particular sentence on page 3 of it that you have to hand up to a witness, hope they don't read the paragraphs above and below it, and hope you don't do something that manages to get the whole thing admitted into evidence. It's very unwieldy, and a committal serves the purpose for an accused person of extracting from that statement those matters that are required to be used at trial and reducing them to a usable form, namely a clear question and answer. Now, the third aspect of the importance of a committal to an accused that I think is going to become more important is that the committal evidence may be admissible at trial as an exception to the general prohibition to hearsay being admitted. Now, there's nothing necessarily new about that. Section 55AB of the old Evidence Act did give the prosecution the right in certain circumstances to apply for committal deposition material to be read in as part of the trial process. Interesting though, under the new Evidence Act, that that procedure would seem to have become easy to use for the Crown, and certainly the impression is given that the Crown will be more keen about using that particular procedure. When you look at section 65(3) of the Evidence Act, after early in the Act stating that hearsay is generally not admitted, it says the hearsay rule does not apply to evidence of a previous representation made in the course of giving evidence in an Australian or overseas proceeding if, in that proceeding, the defendant in the proceeding to which the section is being applied, A, cross-examined the person who made the representation about it, or B, had a reasonable opportunity to cross-examine the person who made the representation about it. Now, the interesting thing there is that whereas under the previous provision of section 55AB of the Evidence Act, one of the qualifying criteria for the Crown to be able to use committal evidence was that the accused was present and that he or his lawyer had a full opportunity to cross-examine the witness. Under the new Evidence Act, word full's not there anymore. It's now described as being a reasonable opportunity. Now, the meaning of that section has been considered in recent weeks in the Court of Appeal, and I've listed the case of the Director of Public Prosecutions and BB, and the Director of Public Prosecutions and QN, which judgment was handed down on the 25th of August of this year. Now, in that case, the trial judge had ruled out evidence of the complainant in a kidnapping matter. The complainant had died between the committal and the trial. It would seem that the evidence was effectively the entirety of the evidence against the accused. So what was being proposed was that the Crown would lead that evidence and effectively the jury would be asked to convict without having seen the complainant have any opportunity to assess their credibility, or indeed have the benefit of seeing the complainant be cross-examined by counsel for the accused. Now, whilst the judge at first instance said, well, it's nominally admissible under section 65(3) of the Evidence Act, under the broader discretion that exists under section 137 of the Evidence Act, she ruled it as inadmissible, and the trial was then adjourned so the Crown could take that matter up as an interlocutory position. And I can tell you the Crown was successful at that time. Interesting to note, Justice Bongiorno said this about the effect of the Evidence Act upon the admissibility of evidence provided at committal. He says, it could be argued that the substitution of the word reasonable in the current Evidence Act for the word full in earlier legislation compels a conclusion that the legislature intended the qualifying condition for admissibility to be now less onerous than it was before. Now, all of the usual complaints you would have expected to be made by the defence about the admission of that evidence were run at the Court of Appeal, and in shorthand, the answer to all of them was matter for directions to a jury. The jury can be told take it into account that you haven't heard from this witness. Jury can be told you haven't had an opportunity to assess their credibility face to face. So it would seem that we are entering something of a new era in relation to the ability of the Crown to use evidence from committal at trial, and certainly the willingness of the Crown to pursue that end, and no doubt it'll be one of the many aspects of the Evidence Act that over the next few years produce some fairly interesting outcomes. Next thing I mentioned about the advantages for an accused going through the committal process is that it creates an opportunity for the resolution of the matter. Now, I say that in a very practical sense because I think we all know that the way in which matters develop their own rhythm is that there are only certain points in the proceedings where there are enough of the right people who are completely on top of the matter to be able to make some judgment call about resolving it. One of those opportunities is at the committal. At the committal, there'll be counsel who has just gone through the committal, understands the strengths and weaknesses of the case. You've got an accused person who has now got a better understanding of the fact that, yes, the witnesses are going to turn up and, yes, they are going to swear up to their statements. And you've also got someone from the Crown who is also fully aware of those things. Now, I know that at the moment the County Court are looking at trying to institute some sort of procedure for targeting that point in the process as one where pleas of guilty can be generated. I don't think it's any secret that the County Court's under an awful amount of pressure at the moment in terms of their listings. I know that Chief Judge Rosines has identified the moment after committal as one of the real opportunities that the court has to sort of get involved and see if something can be worked out. And I think the feeling is that if you miss that opportunity then, well, it goes back to the OPP, gets put in the top drawer. No one really looks at it again until it's coming up for trial, and that's why a lot of matters, I think they suspect, settle on the door of the court. So that is something to be aware of and an opportunity to be taken advantage of. If your client is of a mind to resolve a matter, offers after committal are often accepted simply because people have their minds turned to the strengths and weaknesses of their case at that time. As time goes on, people forget about the strengths, they forget about the weaknesses, and it just gets carried along with the process. Now, the other obvious attractions of committals and that I've mentioned is that, well, you might get discharged, and if you get discharged, you might get costs, and everyone likes getting costs, so that's good. I listed that as last among the matters of importance to an accused simply because on a statistical level and on an analysis of the committals test, discharge is generally difficult. It's something that doesn't occur in a particularly high percentage of cases, but it's interesting looking at Justice Gillard's comments from Williams and Traglia back in 2004 that His Honour seemed to really value the right of an accused person to apply for a discharge and perhaps get costs, which is somewhat surprising. In that case, if you recall, back in the day there was an underworld war in Melbourne and a lot of people getting killed, and there were a lot of trials that were difficult for the Crown in the sense that they were relying upon witnesses who'd been indemnified and witnesses whose health and well-being might have be said was under constant threat. The case of Williams, Brincat and Traglia was one of those cases where they were relying on a witness known as Mr X, and the Crown intention was that get the process over and done with as quickly as possible by bypassing the committal process and listing it directly for a trial in the Supreme Court. Ultimately, it was conceded by everyone that even if it went directly to the Supreme Court, that cross-examination of Mr X prior to the matter proceeding as trial was going to be an important feature of making sure there was a fair trial. But more interestingly was how receptive Justice Gillard was to the arguments that going through this process, even when you gave the accused the ability to cross-examine at a basher inquiry before trial, was in fact a breach of the rights of the accused. And His Honour said, as I've said, he said, history is on their side, referring to the accused. It has always been the practice to hold a committal. It is rare not to do so. Committal proceedings have always played an important part in the administration of the criminal law, affording a protection to the accused, which of course includes the right to make a submission that an accused person should be discharged because the evidence is not sufficient. In addition, there are other benefits of having a committal. The loss of these benefits would prejudice the accused, and this provides cogent evidence in favour of a stay being granted. And His Honour specifically noted counsel's argument that the right to apply for a discharge and the right to perhaps get costs after a discharge was an important right. So it was interesting that Justice Gillard did regard Carl Williams' wallet as being an important consideration in that, but that's probably a good thing. One of the important aspects to consider in going into a committal is obviously whether discharge is a realistic possibility or not. That is something that has to be determined, generally speaking, before the committal starts, unless there's something extraordinary that occurs during a committal, because undoubtedly it will impact upon the way in which the committal is conducted. If someone is pursuing a strategy to get a discharge that involves perhaps not cross-examining witnesses as fully as might otherwise be the case, well, you'd probably want to get that right, because if the person still gets committed for trial, even though you've been attempting to get a discharge, you ended up with a committal that's not as fully conducted as might otherwise be the case. I think when you're considering whether discharge is a realistic possibility, it is always worth familiarising yourself with exactly what the test is for an individual to be committed for trial. Whilst that test is now outlined in the Criminal Procedure Act as being evidence sufficient, I think we all go back to the statement of Thorpe and Abotto as being the test that magistrates apply in determining whether somebody should be committed for trial or not. What's interesting about this test is that I think everyone focuses on what I would say is the first bit of Justice Lockhart's statement, which is that the task of a committing magistrate is essentially to sift the wheat from the chaff. Cases so weak that a jury properly instructed could not possibly convict the defendant, and cases where it could. It is not the task of a magistrate conducting a committal proceeding to assume the role of a jury at a criminal trial. Now, when read in isolation, that doesn't sound too bad. Cases so weak that a jury properly instructed could not possibly convict the defendant, that does seem to, and it does, provide the magistrate with a fair bit of leeway. However, when you read through the judgment a bit further, it's quite clear that the test for committal for trial is arguably lower than even a no-case test. It goes on to say, if a magistrate was obliged to discharge a defendant whenever a hypothesis was reasonably open on the evidence consistent with innocence, albeit that another hypothesis was consistent with his guilt, it is difficult to imagine a case where there would be a committal for trial of a defendant, as there are very few sets of facts or circumstances which cannot admit of, at least in theory, of a possible explanation consistent with innocence. Now, the reason I say that sets a very low bar is that I would have thought at the end of the trial, if you can go to the jury and say there is a reasonable hypothesis consistent with innocence that is open on the material, you get acquitted. In fact, if it's a circumstantial case, you shouldn't even go to the jury on that. However, it would seem that the judgment of Thorpe and Abotto does contemplate a person being committed for trial where the Crown evidence doesn't necessarily exclude a reasonable hypothesis consistent with innocence, as counterintuitive as that sounds. The other reason I say that, and this is a practical consideration as to why it is difficult to get a discharge, is that if you think about the nature in which evidence is given at committal, almost always a witness is presented with a statement, they're asked if it's true and correct, and once they adopt that statement, that evidence stands as the evidence in chief on behalf of the witness. Even, you might think, the most hopeless lying witness can probably manage their way through that particular process. The other practical effect that process has is it does make it very difficult for a magistrate hearing a committal when they're only hearing cross-examination to make a realistic judgment as to exactly how good, bad or indifferent a witness is. They don't get to hear the witness speaking, telling their story from start to finish. They don't get to hear if the witness has forgotten half of their statement, got half of it wrong. They might hear some of that in cross-examination, but they're always going to have that initial statement generally that's been put before them. Now, I can see it is now 8 o'clock, so I won't go on any longer. I've listed what I've said are tips for more effective committals. Now, before anyone sues me, I don't claim to be completely original about any one of these. Committals have been going for hundreds of years, and I didn't invent all these particular pieces of advice myself, but if I could say one of them that I suggest is the most important, and I think probably that applies to each and every committal, it's all about managing your client's expectations. Clients will understand if this is part of a process, and they'll understand and even enjoy if they can be brought in on sneaky plans that counsel have to draw out pieces of evidence and that the Crown won't know about, and it's all going to be a bit secretive. They understand that. They don't necessarily demand huge fireworks and loud cross-examination and that type of thing. I think when managed properly, clients really can understand that this is part of the process and understand that this is all a process to draw material for use at trial. And for that reason, if you understand this process and understand that it is all about the trial, that clients' expectations can be managed quite well, and they will understand and accept the limitations and indeed the huge opportunities that a committal presents. But given that it's 8 o'clock, I will cut myself short there. Thank you very much.
If at the end of the day we still have some time, we'll invite you to ask questions of both Justin and Pat. In respect of committals, can I just make one comment, and that's this: that at the moment we have an Attorney General who, certainly in my assessment, seems to be a strong supporter of committals. Over the years, politicians wax and wane. Over the years there have been debates which have been sometimes got to the stage where we at the criminal bar have thought that committals are going to disappear. If you go to Western Australia or New South Wales to do a case and you stand up and you've had no committal before the case you do, it is sometimes with a sense of abject terror that you ask that question, which hasn't been asked at committal, knowing that you've got to ask it, not knowing what the answer is going to be. We have a responsibility to act responsibly in the way in which we run committals, because you will know that what will happen is that the next time a politician wants to score some points in respect of cleaning up the criminal justice system, he will be there citing any case which shows that barristers or criminal lawyers have been irresponsible in the way in which they've run committals, and particularly where they've wasted time. We rely, when we argue about this, on the fact that committals are an efficient sifting process. We rely on the fact that committals give us the opportunity of working out issues of admissibility of evidence. We rely on the fact that at committals we have the opportunity of identifying weaknesses in the Crown case, which often bring about the opportunity of settling cases which would not otherwise be settled. We also know that committals give the defence the opportunity of working out when in fact they have no arguable defence. These are the things that we need to focus on. Those are the things which people in authority will see as being capable of demonstrating the value of committals. If we act responsibly, we hope that we'll continue to have an advantage which in some other states criminal barristers simply do not.